Mr. Henderson.
Good afternoon.
Good afternoon.
Before I carry on, my learned friend and I had a brief chat about timetabling, which you asked about this morning. We were going to propose that the appellants produce written submissions by the 3rd of December.
Yes. Yeah. I mean, this is, if I understand, but obviously the point hasn't been explained, but I suspect it's quite a short one, if I've defined correctly what it is.
I agree on that, I'm not sure.
So I would, just speaking for myself, I would much rather get the submissions
more quickly.
Quite a lot more quickly.
Okay, should we have another?
I think you perhaps ought to have another chat, but I certainly was thinking of the end of the week, and not necessarily sequential.
Well,
perhaps
it may need to be sequential if the appellant doesn't know what the points are. Because we haven't had it explained to us at all, it's quite difficult.
Would it be better to delay the final decision on this until we've discussed 75A?
Yeah, I mean, you may need to outline for us roughly what the point is without prejudice to your further submissions, so we can reach
a realistic conclusion.
Yeah.
Okay.
But we're thinking of sooner rather than later.
Okay. Thank you.
Thank you.
So I think where I got to in my submissions before lunch was to take you briefly to a passage in the Upper Tribunal's decision, paragraph 157, which is in the core bundle, page 98. Perhaps I could ask you just to read that paragraph 157, please. So the Upper Tribunal is there saying that different circumstances may lead the legislation to need to be applied in different ways. And my short point on that is the Upper Tribunal in my submission was correct to state that that doesn't mean that an implied condition as to validity and effectiveness should be inserted into the statutory language. It just goes to what's meant by a claim having been made. But in any event, as you know, the point raised by the Upper Tribunal doesn't fall to be decided in this case. I was then going to briefly touch on the passage in the HMRC manuals that my learned friend took you to this morning, and those are in the authorities bundle at page 596, please. So this contains, as we saw this morning, a passage about HMRC's approach where a group relief claim was made by the vendor but recovered under paragraph 3 of Schedule 7. And you'll have seen in our skeleton argument that HMRC have confirmed that the bit in inverted commas, that it is not HMRC's intention, that is a limited concession pursuant to HMRC's care and management powers. and so in my submission it can't assist in the resolution of this case. As it happened, I did try to track back to find what the origin of this statement was, because it's slightly unusual in that it's in inverted commas. I got back to, I think originally it was in a tax bulletin 70, which was dated April 2004, where that statement I think originates from.
That's certainly didn't used to be the usual vehicle for announcing concessions. The revenue had a separate method of publishing concessions. So I'm just a bit concerned this it might give the impression of an ex post facto justification.
I'm not sure I can assist any further, my lady. My instructions are that it is now, as at today's date, as it were, considered to be a concession.
And that is because, is it now in another form from what we have at page 596?
No, it's not.
Okay.
That's the version in the HMRC manuals, but all I was saying is that it
I just wondered whether you were saying it is now considered to be a concession, whether something else had happened along the way, but not.
No, all I was saying is that the reason it's in inverted commas is it was first to be found in what's called a tax bulletin.
Yes.
And just in case you do look at that tax bulletin, it's not relevant at all to this case, but there was a typo in the paragraph above with a missing not, then had to be inserted, because otherwise it didn't make sense. But anyway, I'm not sure I can say much more on that.
Well, I understand you can't say more, and that's your instructions. But I would also be interested to understand the revenue's response to this. So what this published practice addresses, practice, concession, whatever you call it, addresses where a situation where group leave has been effectively and validly claimed, using Ms. Shaw's terminology, but is subsequently withdrawn. And the revenue says, right, we won't apply the proviso in that situation. But what would happen if group leave had been claimed, not found to be available, and tax was assessed? The same tax that would have been assessed if there had been a clawback. Is the revenue potentially going to say, well, we'll apply another concession in that case, because I think that's the logical consequence of your arguments? Or are they going to say, no, we're going to draw a distinction between clawback, where there's a concession, and failing to get your claim through in the first place? And even though you've paid tax in both cases in the same amounts, we're going to draw that distinction.
If I may, I'll take instructions on that
Yeah.
overnight and get back to you, rather than just give an off-the-cuff response.
Well, it seemed to me, with respect, that's a response that ought to have been, it's an obvious point to raise, and I would have thought, given I drew specific attention to this bit of the manual in the...
I mean, I can say this, my lady, that I think on the logic of my argument, I would have to accept, wouldn't I, that the mere fact that Company A, as it were, ultimately is assessed tax, wouldn't prevent the proviso from applying to Company B in the example we were using before lunch. But, as I say, I would like to take instructions and just double check that the clients behind me agree on that.
Can you give us the date when these provisions came into force? You were talking about a tax bulletin in April 2004.
Yes.
This was the Finance Act 2003.
Yes.
Do we have a commencement date?
For the FA 2003?
Yeah.
I think they did come in 2004, if I recall correctly. I mean, obviously it took a while for the system to be put into effect. There will be a commencement date somewhere.
I've been told it's 1st of December 2003, but we'll double check that and let you know if that's not right.
Thank you.
So, next point, the appellant raises the prospect of where a claim for group relief in respect of a prior transaction is not in fact made until after the effective date of the distribution. And in response to that, my submission is that the focus of the proviso to case 3 is clearly on a prior transaction preceding the distribution transaction. In other words, in my submission, it's clear that what's being identified is a transaction in the last 3 years in respect of which a group relief claim was made. So I submit that that point doesn't assist the appellant. And finally, in terms of the appellant's points, I don't think my learned friend pressed this morning, but there was a reference in there, there's an argument to a prize or reward being claimed. And I think the suggestion was that you don't claim a prize or reward unless you're sort of entitled to it. In my submission, the use of claimed in an entirely different context doesn't assist in interpreting the SDLT legislation, the provision in the SDLT legislation we're concerned with, where the concept of making a group relief claim on an SDLT return is a legal process that's very well understood. So that's all I say on that. So, in summary, on ground 1, I say section 54 4B is clear in its terms. It requires merely that it's not the case that, in this case, the lease has, within the period of 3 years immediately preceding the effective date of the transaction, been the subject of a transaction in respect of which group relief was claimed by the vendor, here B64. I submit there's no way to interpret this provision other than by looking at whether the vendor has made a group relief claim. And we've seen that it's the obligation of the vendor to complete its SDLT return on the basis that it's to the best of its knowledge correct and complete. And in the vast majority of cases, of course, that will be entirely uncontroversial. This case has thrown up peculiarly complex fact pattern, given the circumstances and the arguments that have been advanced. In terms of the appellant's interpretation, no materials have been put forward to justify why it should be interpreted as they suggest. And I've made the point that their interpretation gives rise to significant uncertainties. When do you apply the test? What happens if different courts change their view and so on? And how do you test a point subsequently if, as here, the relevant connected company's tax affairs are not actually under consideration? Is a taxpayer entitled to say later, oh well, that company shouldn't have got group relief? How can you test that? Even leaving aside complex issues of taxpayer confidentiality.
But aren't there so many, you could come up with numerous examples where a taxpayer just has to do that. Let's take one example where you're trying to calculate the gain on the sale of an asset you hold, which you believe has been the subject of a number of prior intergroup transfers and maybe things like business asset rollover relief. You're dependent on information related to other transactions involving other companies. part of what being in a group involves. So there's all sorts of uncertainties you could point to. So I'm not sure how far this argument takes you.
Well, I think it would be, my submission, quite stark in this case, or a case such as this one, where you'd be having a, yes, as we discussed this morning, there might be times when the company is filling out its tax return, it has to take into account information relevant to other taxpayers and so on. But what we're envisaging here is that it's possible years down the line for the SDLT treatment of a transaction entered into by a company that is not party to the litigation to once more be put under the microscope and conclusions having to be reached. Now, those conclusions might, as in this case, have to involve things like purposes, and whether that company entered into the transaction for bona fide commercial reasons and that sort of thing. It becomes very messy in my submission once one moves away from the simple approach, which is, has my fellow group company or my connected company claimed group relief? Usually that claim for group relief will be entirely uncontroversial. You fill out your return, and that's how one reads the proviso to subsection 4b. So I invite you to interpret. So that was all I was proposing to say on the appellant's ground one, unless I can assist any further.
Thank you.
So then ground two, the 3-year period issue, we deal with this at paragraphs 27 to 35 of our skeleton argument. And as you know, the appellant's ground two entails arguing that the earlier transaction between SGSL and B64 did not take place within the period of 3 years immediately preceding the effective date of the transaction. And the appellant's argument, in other words, is that the 3-year look-back period begins the day before the day on which the transaction we're concerned with took place. So any transaction executed earlier on the same day as the distribution transaction will not trigger the proviso. Whereas if the same transaction were entered into the day before, or indeed any point in the previous 3 years, then it would do so. And we say this would clearly be an absurd result. And as my lady just Falk put it in the permission decision, a surprising loophole in the legislation. Now, the appellant's construction relies on the proposition that Parliament intended to create a gap, a window of opportunity from midnight the day before the distribution transaction and closes once that transaction is complete. And obviously that window could enable groups to effect intragroup transactions on that day and claim group relief in respect of them without triggering the proviso.
Does one have to go as far as to say that Parliament intended to create a gap? One has all sorts of situations in which there are loopholes which were not intended but are clear from the wording read in context. One doesn't have to actually assume that a loophole was intended or a gap was intended.
I take that point, my lady, and maybe I should put it more positively, that it's clear that Parliament's intention was to cover transactions 3 years before the...
There would be no gap.
There would be no gap.
I think actually, to be fair, Ms. Shaw explicitly said that was not her case, that Parliament intended to create a gap. She said that the language that Parliament used could not be construed in any other way.
Yes.
That was the answer.
Yes. But it may be there's a degree of common ground here that it would be an absurd result in circumstances where clearly what was being envisaged is a look back of 3 years. And obviously I accept that the appellant's interpretation, whereby there is this gap, is a possible linguistic interpretation of the legislation. But as my learned friend showed you some of the cases on purpose of interpretation, that can't be the end of it. And I wanted to take you to one of the authorities that we rely on in the authorities bundle, which is the case of IRC and Luke, behind tab 9 on page 557 of the authorities bundle, please.
Luke 171.
Oh, sorry.
Five and 9.
7-9.
Sorry about that.
5 and 9. It's 557 of the actual report.
Yeah, that's right. Apologies. So, in this case, the House of Lords was grappling with a statutory provision that suggested that a director in that case, or perhaps actually, sorry, can I ask you to read the head now? That's probably the quickest way of dealing with it. Thank you. So here the court was grappling with a statutory provision that suggested that the director in that case should be treated as receiving taxable emoluments where the company was merely incurring normal landlord type expenses, rates, insurance and so on. And then can I take you to the well-known passage of Lord Reed, which is on page 577 of the authorities of the report and page 191 of the bundle, please. And he says in the second paragraph there, how then are we to resolve the difficulty to apply words literally as to defeat the obvious intention of the legislation and to produce a wholly unreasonable result? To achieve the obvious intention to produce a reasonable result, we must do some violence to the words. This is not a new problem, though our standard of drafting is such that it rarely emerges. The general principle is well settled. It's only where the words are absolutely incapable of a construction which will accord with the apparent intention of the provision and will avoid a wholly unreasonable result that the words of the enactment must prevail. And then what Lord Reed goes on to do is look at various possible interpretations, and he finds that he can avoid what he saw as the unreasonable result. Could I then also just take you to a passage in Benyon in the authorities bundle, which is on page 584, the authorities bundle, please. And firstly, paragraph 13.1, presumption that absurd results not intended. Perhaps I could just ask you to read to the bottom of that page, please.
I'm sorry, just give me a moment. So, page
584.
Thank you.
And then if I could ask you to turn over to page 585, please, and just read the first 4 paragraphs under the heading Nature and Strength of the Presumption. And then lastly on this, just for completeness, over the page on page 586, whether there is a cogent statutory scheme, the presumption against absurdity is simply a guide to legislative intention, and is therefore most likely to be successfully relied upon where the alleged absurdity is not a necessary consequence of an otherwise cogent statutory scheme and cannot be justified on other grounds. Now, I would submit that the statutory scheme here is section 54, section 53 read with section 54. I anticipate my learned friend might say the statutory scheme is the whole of the FA 2003. But in any event, just as an aside, we noticed, looking at this passage, there's quite an interesting case cited, the second example, which is also one of the another time after a date cases. Maybe just ask you to read the summary of R and Leher, please. So before addressing on how the proviso in section 54.4 might be read to avoid what we say would be an absurd result, maybe I don't need to do. I was going to take you to the explanatory notes, but you did see those this morning, and those do say 3 years prior to the transaction.
It's very difficult to put much weight on that, isn't it? I mean, they're a boiled down version for the more general reader, and they can't prevail over the language of the statute.
I take the point, my lord. They are, however, consistent with what I say is the sensible interpretation of the statute. And what they don't say is something along the lines of we're going to use effective date because we're using it in the rest of the SDLT code. But yeah. So then turning to how the legislation might be interpreted to avoid this consequence, I think there's 3 that I would advance. First one is the Upper Tribunal's interpretation that my learned friend has already taken you to, but perhaps we could just go back to that brief passage. It's on Core Bundle, page 99. And starting at 159, perhaps I could just ask you to reread those paragraphs down to 162, please.
Thank you.
So the Upper Tribunal took the view that the relevant look-back should be interpreted as the 3 years prior to the transaction itself. And I submit that that is a perfectly permissible, purposive interpretation of the relevant words, and we're all aware of many cases where more extravagant interpretations have been accepted by the courts to avoid the sort of outcome that the appellants are suggesting for in this case. So that's our primary position, but a bit like Lord Reed in IRC and Luke, we've considered other possible interpretations, and we set out 2 of these at paragraph 34 of our skeleton argument. So the first is that the proviso could be construed as including all events up to and including those on the effective date of the transaction. If we go back to the legislation, there is in the wording between the commas a limitation to a period such that only group relief claims within a particular period, 3 years, are caught. And we say this limiting wording could sensibly be construed as comprising the period of 3 years up to and including the effective date. Now, importantly in my submission, this wouldn't result in the disapplication of the Case 3 exception where the relevant group relief claim is made in relation to a later transaction on the same day, because Case 3 is still limited to instances where there has been a relevant prior transaction. In other words, the relevant statutory words have a sort of ordering effect. Has there been a relevant prior transaction? So in my submission, reading in the words up to and including before the words effective date involves, again in my submission, a perfectly legitimate form of purposive statutory interpretation to give the sensible result. The second alternative way of reading the proviso in section 54.4, and as we've seen this morning, the Upper Tribunal disagreed with this suggestion with advance there. I wasn't involved at the Upper Tribunal level. But if necessary, the term effective date in the proviso could be read as referring to the particular time at which the transaction in question happened. Now, in the Upper Tribunal, reference was made to the Oxford English Dictionary definition of date. I'm not going to seek to rely on that. We just mentioned that in passing. But the effective date could be read as meaning the time and date of completion, so as to accommodate which transaction occurred first. Now, as we say in our skeleton...
So, but in the forms that we were shown this morning, one didn't have to put down the time at which the matter was completed, just the date, didn't one? That was all
correct.
that had been filled in, put it that way.
Yes, I think that's correct, my lady.
Sorry to interrupt you.
That's okay. I mean, it's an obvious point really, but I mean, obviously in 99.9% of transactions, the specific time is not of any
But you have to address that effective date is a defined term.
It is a defined term, my lady, yes.
So are you reading it generally in this way, or or as making some sort of exception?
Well, it's on this argument, on my up to and including it,
but I realise we're on this particular argument, which is not your only one.
And I confess, I think the up to including is probably the best of the three, as it were.
So your second one you think is the one, that's the second of the three, I think.
But I'd say a bit like law, I think it's permissible to try different ways of getting to what the result should be. And say interpreting effective date as the time and date of completion, yes, my lady, I accept it's quite challenging given the definition of effective date. But what it does do at the very least is put one on notice that there are cases that my learned friend briefly referred to this morning where the courts have, in different contexts, bent over backwards to ensure that they adopt an interpretation that doesn't lead to an absurd result. So, could I take you very briefly to the cases we've referred to in our skeleton? So, Eagle Hill first, which is behind tab 11 on page 209. And the issue in this case is whether a notice of dishonour of a bill of exchange was valid, and this turned on whether the notice of dishonour had been given before the bill of exchange was in fact dishonoured. And perhaps I could ask us to pick it up in the speech of Viscount Dilhorn at page 1006A of the report, which is on page 223, please. So he says there, so the question to be resolved in this case is were there grounds for concluding that the notice was given directly the bill was dishonoured or thereafter, in which case it was a good notice. It was argued that the law does not have regard to parts of a day. This is true in relation to the computation of a period of time, but is not the case where it's necessary to establish a sequence of events, see Campbell and Strangeways. And then in Castrique and Bernabo, notice of dishonour of a bill was posted on the day on which the action was commenced. Under the post office routine in 1844, it would have been delivered between 4 and 5 the same day. No further evidence was given as to the time of receipt. The writ must have been issued before 5 p.m, and it was held that the action failed as the plaintiff had not shown a right of action existed before the commencement of his suit. This direction shows not only that where it's necessary to determine the sequence of events, regard be had for the parts of the day, but also before the Bill of Exchange Act 1882, it was the receipt of the notice, not the time of dispatch, that had to be considered. And then if we go to Lord Cross at page 1010, on page 227 of the bundle, he says, Lord Denning MR says in his judgment that it is a general rule that the law pays no regard to parts of a day. That is of course true if what one is concerned with is the calculation of a period of time, but with respect it's not true if what one is concerned with is a sequence of events happening on the same day. And then in that regard...
But here, are we concerned with the sequence of events? We're concerned with a period of time, 3 years, from a particular date, and it depends from a particular stick in the ground, put it that way, a marker.
My lady, my submission on that would be we are concerned with the sensibly we are considered with the sequence of events.
Okay.
We're concerned with whether there has been a prior group relief claim prior to the transaction that company is that taxpayer is actually entered into. So it is a sequence. It's has something happened in the last 3 years?
Okay. Mm-hmm.
So then I'll take this as quick as I can because I know my friend referred you to them, although I think it was only the head notes. We just look at Campbell and Strangeways case. This was the dog licensing case. Let's just remind yourself of the head note on page 166 of the authorities bundle.
This is the defendant trying to take advantage of an assumption that something happened before it actually happened.
Yes.
A legal presumption, which is quite a different kind of situation from ours, isn't it?
Well, he hadn't got a dog license at the time he was caught.
Correct.
And then got one later in the day and said, oh, well, the legislation says it's as long as they have one on the day.
Well, does he say that? I'm not sure this turned on the terms of the legislation. The charge, the information was that he, on the day, he kept a dog without a licence.
Yeah.
So it doesn't seem to be something that turns on the terms of the legislation, simply on whether he, on that day, kept a dog without a licence. He did.
He was relying on the legislation that just talked about having a licence on the day. I think that's right, my lord. And the very brief judgments in that case, Mr. Justice Grove and Mr. Justice Lindley, they find no difficulty in saying, well, we're not going to accept this argument that you had a licence on the day when in fact you didn't have one when you were caught without one. So they give that sort of argument pretty short shrift. And then to similar effect, there's the case of Heath and J.F. Longman, Meat Salesman, which is behind tab 10 of the authorities bundle. Again, perhaps I can just ask you to refresh your mind from the head note. It's a short head note. And then I'm happy for you to read this up. The passage I was going to invite you to read is starts on page 1230 at the paragraphs starting, "It's quite clear from those findings," and then down to the very top of page 1232 of the report, page 208 of the authorities bundle. I wonder if you could just read that now, if you're happy to do so.
Thank you.
Can I just raise this? Maybe there may be a short answer to this, but I note in section 119 which defines the meaning of effective date, there's a provision that allows the commissioners to prescribe by regulation an alternative date.
Yeah.
Unusual, some sort of ability to change the meaning of the words. Does that have any bearing on this case? Is it something that could have been done to bring about the result that you're straining to achieve by other means?
Well, I suppose it could have been done, or it could have been done by wording along the lines of up to and including within the Section 54 itself. It's not as if the definition of effective date would necessarily have had to be changed, or indeed. So I think the short answer to your question is it doesn't have any bearing in the sense that I'm not suggesting that HMRC have used that power. How they, if you were to decide that there was a problem in terms of leaving this gap on the day of the actual transaction, then obviously HMRC will have to think very hard about how to prevent that happening for the future. But I'm hoping that you will find an interpretation that avoids that patently absurd result. And that's why I've taken you to these cases. You may not be with me on date, can mean time, whatever, but what these cases show is courts reaching sensible results, not letting people get away with the sort of techie arguments about, well, it says effective date, that must therefore end on midnight the day before. And we've seen in the cases we looked at, the courts generally give those sorts of arguments short shrift.
You've taken us to a line of cases which Benyon calls presumption against absurdity. There's another line of cases, the leading one being, I just wanted to mention this, Inco Europe against First Choice, which is more usually phrased in terms of drafting errors. I just want to clarify, you've not raised that, but is that a relevant area to think about?
It is, well? And that, I mean, I haven't cited Inco Europe, but I have cited O'Rourke and Binks, which I would say is in the same ballpark as Inco Europe.
Yeah, but Inco is later and House of Lords also.
Yeah, but I've also cited IRC and Luke, which is to the same effect. So
I'm not sure they say exactly the same things. There's a slightly different approach.
Yes.
Potentially.
But I certainly, my lady, I rely on that sort of thinking, that where necessary, the courts have to remedy the damage that would be done by overly literal interpretation. And that's what the court was doing in O'Rourke and Binks. Same in IRC and Luke.
So you think there's no fundamental difference between the approaches?
In those cases?
Well, you could, would you say you could look at this through the lens of Inco Europe?
Yes, yes. In fact, I'd go so far as to say I think one has to. So can I now deal with some of the points my learned friend has made on this ground? First of all, she says the term effective date is a defined term. It's used multiple times in the SDLT code. Obviously can't deny that that is the case, but we submit, as you know, that a sensible purpose interpretation of this particular statutory phrase has to be arrived at. And can I take you on that, just to a very brief passage in a recent case called Brown, a Court of Appeal case on SDLT, which behind tab 21. this case concerned quite an aggressive SDLT scheme, but I just wanted to show you the passage of judgment of Lord Justice Lewison at paragraph 34 on page 390 of the authorities bundle. So he's just referred to Ramsey and Rossendale, and then at 34 he says, it thus follows that no statute is excluded from this approach. Moreover, even where the statute uses concepts or phrases which have a general meaning in the law, such as in Rossendale entitled possession, it's still necessary to apply a purposive interpretation. I accept here that effective date isn't just a general meaning in the law, it does have a statutory definition within the FA 2003, but as I've sought to submit, there are quite light brush, as it were, ways of interpreting the proviso to ensure that the result the appellant argues for doesn't get home. So in terms of the other references to effective date, in my submission there's no problem with, for example, employing the normal definition of it in section 76. As I say, what has to be interpreted here is the composite phrase in the proviso. Has, within the period of 3 years immediately preceding the effective date of the transaction, been the subject of a transaction in respect of which group relief was claimed by the vendor. The appellant makes the point that the legislation doesn't say immediately preceding and including the effective date. Well, obviously it doesn't. We wouldn't be here arguing about it if it did. But you have my point that you can get to that sensible purposive interpretation. And then we cite in that regard O'Rourke and Binks. And can I just take you to a couple of passages? I don't need to go through the facts again because my learned friend did that this morning. But it's behind tab 14, page 244, starting at 244, please. So the background is set out next to letter F. This is where they explain the difficulty with the provisions. We may not need to go to that. Sorry, bear with me. So the Court of Appeal had to decide was whether section 72.4 should be read as though after the word where, the limitation in a case in which the amount distributed is small compared to the value of the shares in respect of which it's distributed. And then we pick it up at 709 E, and I ask you just to read those in the paragraph beginning in Luke and IRC. Just the marked passage there, and then please also the marked passage over the page on page 710 of the report, beginning in my judgment. my learned friend relies on various cases on limitation periods and time limits and so on. I submit that there's limited assistance can be gained from those cases. They're distinguishable as they're focusing on establish what's a correct forward-looking time limit or limitation period. By contrast, the present case involves a backward-looking time limit, and the appellant's interpretation of the proviso would give rise to absurd consequences. And I repeat that in this provision, it's necessary to work out whether one transaction occurred before another transaction. That doesn't really arise in the cases like Dodds and Walker and the 79 divorced couples cases that my learned friend has cited in my learned friends have cited in their skeleton argument. So, like my learned friend, unless you want me to, I wasn't planning to take you through those cases. My learned friends refer to a passage in Halsbury's which talks about the general rule is that the effect of defining a period in such a manner as from such a day is to exclude the first day and include the last day. Even leaving aside my point about that comment is largely in relation to forward-looking time periods, Halsbury then goes on to say, well, just take you to it, it's page 581 of the authorities bundle. So there's where a law or contract prescribes a period of time running from a given day or event to another day or event, and the question arises whether the computation is to be made inclusively or exclusively of the first mentioned or the last mentioned day. Regard must be had to the context and to the purposes for which the computation has to be made. Where there is no room for doubt, the enactment or instrument ought to be construed so as to give effect to and not defeat the intention of Parliament. Sorry, where there is room for doubt, the enactment or the instrument ought to be construed so as to give effect and not defeat the intention of Parliament or of the parties, as the case may be. And then at paragraph 346, I apologise, I think it's in an earlier volume of Halsbury's, but I checked and it's the same in the latest volume on page 578. The general rule that fractions of the day are to be disregarded does not apply where the object of a statute would be defeated unless the precise hour of an occurrence were noted. And that's a bit, and the Campbell and Strangeways case is cited there. But if we stand back from all these cases and Halsbury, the mere fact that sometimes the courts will not count parts or fractions of a day doesn't mean that one applies the idea in a non-thinking way. And where Parliament's intention will be defeated by taking an overly literal view of a provision, then it should be interpreted purposively to avoid results not intended. And then finally, my learned friends make a point about, well, if the look-back period starts, say, from the transaction, doesn't that cause you a problem at the beginning of the 3-year period? That may be a pretty theoretical concern. I would have thought that trying to catch transactions close to the one you're actually focused on, including on the actual day of that transaction, is a more pressing concern than having a debate about what may or may not have happened on a particular day 3 years previously. But in any event, for example, on the up to and including interpretation, that solves the problem. It would lead to a very clear start point for the 3 years. Unless I can be of any further assistance on ground 2, that's all I was going to say.
Thank you very much.
May I make 2 points in reply, please? Firstly, on ground 1, the point was made that SDLT is a self-assessed tax, and in our submission, the fact that SDLT is a self-assessed tax does not mean that the die is cast, if you like, as at the time of the return. If the claim is invalid and ineffective, there is no reason why that cannot and should not be taken into account, especially in the context of an assessment which is predicated on the invalidity and ineffectiveness of the claims. The essence of the revenues case is that the purpose of 54(4)(b) is not just to prevent the clawback of group relief from being sidestepped, it's that it's there to punish those who make claims for group relief, even if they do not in fact ultimately enjoy the benefit of that group relief. And we say still no explanation has been offered as to why Parliament should be taken to have intended that the deemed market value rule should apply in circumstances where a claim was made, it was invalid and ineffective, and the benefit of group relief has not been enjoyed. And then secondly, on our ground 2, can I reply somewhat on the hoof to the INCO point that was raised just a moment ago? In our submission, INCO is concerned with the rectification of obvious transposition or drafting errors. That is not what has happened here. And that is not the case with loopholes. Loopholes arise as a result of oversight. They arise because the particular situation at issue was not in the mind of the legislature at the time the legislation was drafted. That scenario, unintended loopholes, is not what INCO addresses. If INCO was a fix-all for defective legislation, then, to my point, you could never have a loophole. You'd simply ignore the words or read in the words around it so as to avoid that loophole ever arising. And if INCO was a fix-all, the approach in Project Blue would have been very different. Now, it is telling that my learned friend has not addressed you at all on Project Blue. And it is clear, we say, from Project Blue, that this is the very statutory code that is particularly prone to loopholes, but that is not a basis on which to enter into or engage in any other exercise other than a legitimate process of interpretation. That was all I had in reply. Thank you.
Thank you.
So, unless you wanted to break early, we were going to push straight on.
Absolutely.
With
We're into
75A.
75A.
And I'm going to hand over to Mr. Brodsky.
Thank you, Mr. Brodsky.
I'll be addressing the court on behalf of the appellant as to why Section 75A of the Finance Act 2003 does not apply so as to increase the tax payable by the appellant. And this issue, as Ms. Shaw has explained, arises only if the court finds for the appellant on one or both of its grounds of appeal. In terms of the structure of my submissions, I'm going to start with a brief overview of that section and of the two areas of dispute between the parties on it. I'll then spend a bit more time on the legislation and highlight a few of the particularly important background facts before developing my submissions on each of those two areas of dispute. So, as the court will no doubt have picked up from the pre-reading, Section 75A is an anti-avoidance provision that, in shortest summary, will apply, taking the paradigm case, where the parties are contemplating a transfer of land, say from A to C, which would be subject to SDLT, but instead they enter into some sort of scheme where it goes round the houses, say from A to B to C. And as a result of that scheme, less tax, less SDLT is due. That is what we say is the paradigm case. And what Section 75A does in that case is to charge tax by reference to what would have been charged if the parties had just done that direct transfer. So in the example above, from A to C directly. And that is what the Supreme Court said its purpose was in Project Blue, which I'll come back to, but for your note, it's the Authorities Bundle, page 289, paragraph 42. The revenues position, as set out in the respondent's notice, is that Section 75 is engaged and will charge the appellant to tax, even if the appellant is successful on one of both grounds of appeal by reference to this notional transaction. Our position is that Section 75A does not have that effect because that notional direct transfer would attract group relief and so would be exempt from charge. That is the first area of disagreement. The second area of disagreement will arise only if the court finds that group relief does not apply to the notional transaction. And in that case, the revenues say that Section 53 would apply to the notional transaction, which we accept, subject to the application of Section 54. And we say that the Case 3 exception in Section 54 would apply to the notional transaction, so as to switch off Section 53. So if we can turn up Section 75A, which helpfully is page 75 of the Authorities Bundle. Could I ask the court to read subsection 1 and subsection 4? There are a few aspects of Section 75A which I'd like to emphasise. First is subsection 4A, which provides that where Section 75A applies, the scheme transactions, which are land transactions, are to be disregarded. Subsection 4B defines the interest which is being transferred from B to P. Subsection 5 sets out how you define the chargeable consideration for the notional transaction. And subsection 6 tells you how you work out the effective date. All of those things are defined by the legislation. And if we turn to page 77 of the Authorities Bundle, we have there section 75C, which provides supplemental provision in respect of section 75A. And there are some important provisions there. So firstly, subsection 2 which provides that the notional transaction under section 75A attracts any relief under this part which it would attract if it were an actual transaction, subject to the terms and restrictions of the relief. And also importantly, well, on subsection 2, the point I make just at this juncture is that what subsection 2 is doing is asking what reliefs would apply to the notional transaction. That's why it says it, which it would attract if it were an actual transaction. So that's the statutory test, not what reliefs would it attract if it were imbued with the purpose of the scheme transaction, or what reliefs would it attract if it were part of the scheme transaction. Then we have subsection 3. Can I just ask the court to read subsection 3, please? So neither party says that subsection 3 applies in this case, but it's an important legislative clue, because what subsection 3 does is say, for the particular purposes where it applies, dealing with acquisition and reconstruction relief in Schedule 7, which aren't relevant to this case, but it says that in that case, you can read across purpose. So it's telling you that in one particular case, you do read across the purpose of the scheme transactions to the notional transaction. And then also relevantly in section 75C, we have subsection 6, which is what tells you that section 53 applies to the notional transaction as well. I'm not going to take you to the group relief provisions because the court's already been taken to those this morning, but also relevant to the section 75A point is Schedule 16, which is at page 140 of the authority bundle. And just at the bottom of the page, we see the heading Bear Trustee. And could I ask the court to read paragraph 3 just over the page? Essentially, what this rule is doing is to say that you look through bare trusts as a general rule, and SDLT applies on the beneficial owner, except for the grant of a lease, where the rule is different. And essentially, that was an amendment to paragraph 3, brought in to tackle a particular type of avoidance scheme that used the grant of a lease to a bare trustee and then the assignment of that lease to a third-party purchaser.
It's common ground here, I take it, that paragraph 3 sub 4 applies
Yes,
to the lease grant.
yes, and to the notional transaction under section 75A.
Because the first of the two transactions was actually a lease grant, the second was a transfer.
Was a
wasn't it?
transfer.
So how do you say the notional transaction can only be a lease grant? Am I missing something here?
So there isn't a dispute between, as far as I understand it, it's common ground that the notional transaction is the grant of a lease.
Okay, well that's helpful to understand. So you think it's common ground that the notional transaction is a lease grant,
Yes.
and looking at paragraph 3, sub 4, that looks like the appropriate
Yes.
provision.
As I understand it, that's common ground. In effect, the notional transfer couldn't be the notional transaction couldn't be the transfer of the lease because the lease wasn't at that point
Yeah.
existent. And the second Section 75 issue turns upon the interpretation of that provision as it applies to the notional transaction. So, turning to the facts, there are a couple of key facts that I'd like to emphasise. And if we could go to page 71 of the core bundle. We have there at the bottom paragraph 17 of the Upper Tribunal's decision, where it's quoting from the FTT's finding of facts. And could I ask the court to read paragraphs 41 and 42 as quoted there? There are three particularly important points which we say emerge from that. First, that if the group had never taken, followed or received PwC's advice and the tax plan, it would have done the direct transfer as originally envisaged. That direct transfer would have been for commercial purposes, and it would not have been for any tax avoidance purpose. And it would therefore have qualified for group relief. Second, that direct transfer could not have given rise to a corporation tax advantage. It was never envisaged that it would, never envisaged that it might. And third, that the group relief anti-avoidance provision, para 2(4)(a) of Schedule 7, has already bitten the appellant. Because even if the appellant succeeds on its appeal, it accepts that SDLT is due on 30 million, the book value, and that would not have been payable if that direct transfer had just been carried out, if there had been no following of PwC's steps. So turning now to the group relief issue as it applies to the notional transaction. It is common ground that the notional transaction is the grant of the tower lease from SGSL, who started off with the interest in the tower, to the appellant, who ended up with the tower lease. And it is common ground that a notional transaction is, in theory, capable of qualifying for group relief, provided that it meets the terms and restrictions of that relief. The revenue accept that, and in any event, it's the consequence of section 75C sub 2. And it is also common ground that the notional vendor and notional purchaser were members of the same group as at the relevant date, so as to meet the primary condition for group relief. The question which arises is whether, which is the revenues case, the notional transaction is barred from group relief because, essentially, the scheme transactions were barred from group relief because they were entered into, along with the commercial motive, an avoidance motive, a motive to avoid corporation tax. And the revenues say that you read across that purpose from the scheme transactions to the notional transaction. Our case, in a nutshell, is that the notional transaction qualifies for group relief, and there is no basis in law or in fact for transposing that purpose. And the reasons that we say the court should prefer our construction are as follows. First, at a high level, section 75A charges tax by reference to a notional transaction, not the transactions which in fact took place. And there is nothing in section 75A which expressly or by implication imputes a tax avoidance purpose to that notional transaction from a separate and distinct transaction. There is, in short, no direction in the legislation for a court or tribunal to do that. Secondly, the legislation could have made that express provision, and it would have been quite straightforward for it to do so. And indeed, that is what the legislation did in a particular case, which we've seen in section 75C sub 3.
Do you say that the absence of any equivalent provision from 75C3 means that you can't attribute any motivations, purpose, reasons to the notional transaction?
Well, we accept that group relief, when determining whether or not group relief applies, you have to consider some purpose.
Well, yes, I'm looking at the group relief requirements,
yes,
which is actually phrased in negative terms. It's not available if the transaction is not effective for bona fide commercial reasons or has a tax avoidance purpose. So, what are you saying that one should do when in relation to those requirements, both limbs of them, when trying to see if group relief is available for a notional transaction?
The statutory question is to ask what reliefs would the notional transaction attract if it were an actual transaction. So in this case, if the parties had carried out the notional transaction and were told what the subject matter of the transaction is, were told what the date of the notional transaction is, had the parties carried out that transaction, would group relief have been available? And there's some hypothesizing for the court to do, but we have all the facts found by the FTT and endorsed by the Upper Tribunal. So So we know that on these facts, if the parties had carried out that direct transfer, they were contemplating it, there would have been no avoidance purpose.
Well, we know that we have some findings about what the position might have been if they hadn't gone off to PwC. I'm not sure that quite translates into what must be treated as actually happening when they did implement the scheme. I mean, in a way, the FTT's findings look at the position before, at an earlier stage, and not at the position when the transactions were actually implemented.
Well, the FTT was made findings of fact about what the group was considering before it got that step. And I mean, if we turn up the group relief provisions and apply them to the notional transaction, so para 24A of Schedule 7.
Page 131.
131. So first is effectively, is the notional transaction effective for bona fide commercial purposes? Now, even the scheme transactions met that, so the revenue aren't saying the notional transaction fails that condition on our facts. We'll come back to in a moment what that tells you about the read across in general, but on our facts they accept that's met. So then we have B. Does the notional transaction form part of arrangements of which the main purpose, or one of the main purposes, is the avoidance of liability to tax? So the notional transaction didn't form part of those scheme arrangements. And we know that it couldn't have had a corporation tax advantage. The parties never thought that it would. So what the revenue...
Well, I'm not... I suppose that's really what I'm asking. So... the transaction that we're asked to consider under 75A is one where the land transactions have been disregarded. Not all the transactions in the scheme, the land transactions have been disregarded, and you have this notional transaction.
Yes, and one of the key reasons why you disregard the land transactions is because otherwise there'd be tax on those land transactions in addition to the notional transaction.
I understand that, but I'm just making the point that we're not in an entirely notional world. Some things are left in place, which might vary depending on the circumstances, but in this case it might be said that the scheme transactions include the transfer of the shares of B64, for example. That's not ignored. I'm just need a bit more help on, I suppose, how much make-believe and how much real world you're trying to apply.
It's helpful to think about the paradigm case, because if you accept that the paradigm case is the parties could have done a transaction directly, I mean, in this case, if they'd done it directly, there would have been group relief and no SDLT. So the effect of what the revenue is saying is that it becomes more than an anti-avoidance provision, because it does more than get the revenue back to the position that they would have been in if the parties had never entered into the avoidance transactions. So if they'd never entered into the avoidance transactions, there would have been no SDLT. And the effect of what the revenue is saying is that there's SDLT payable on £200 million. And I suppose there's one question, which is how much do you read?
Sorry, can I just pursue this a bit further? Apologies. Just looking at the group relief requirements in 2.4a, you've addressed subparagraph little a, not effective for bona fide commercial reasons.
Yeah.
Little b, the critical question is whether, presumably, is whether the notional transaction forms part of arrangements of which the main purpose, or one of the main purposes, is the avoidance of liability to tax. What do you say to that? Do you say that in the scenario we've got, it can't have formed part of such arrangements?
Yes, absolutely.
Because it's only, and just understand why that is. Is it only the lease grant to B64 and the assignment that are said to have possibly that purpose in mind, whereas the notional transaction couldn't?
The notional transaction sits outside the arrangements that the parties actually entered into, is our case.
Well, I think that's what I'm testing, because I'm not certain to what extent that's the case.
Well,
and that's really what was intended.
Well, the notional transfer is a notional direct transfer. So it's contemplating what the parties would have done if they'd done the simplest thing. So it's hard to imagine how you marry together the notional direct transfer from A to C with certain remnant parts of the scheme transactions. There isn't what would that transaction look like? It's impossible to tell. How would you define the tax that would be payable on that notional transaction, on those arrangements? Because the notional direct transfer is simply a transfer that has been done directly. The parties are agreed on to what that notional direct transfer is, agreed on who V is and who P is and what it is, and it doesn't involve a share sale. All it is the grant of a lease.
Well, I don't, yeah.
So, if I might add to that, what legs, therefore, does para 2 for capital A B have in relation to a notional transaction? Because you've sort of sterilised your notional transaction because it's notional. So you said you think about it separately. But if that's the case, then B, little b of 4 capital A, is always sort of worthless, isn't it? Because that notional transaction, as I understand the way you're putting it, is never going to form part of arrangements of any kind. It's always going to stand on its own. Is that right?
Well, that is part of what we say.
Right.
We also say that when you're asking the statutory question in this case, we know that it wouldn't have formed part of such arrangements. It makes no sense to posit a direct transfer that could not have saved tax. It was never envisaged to save tax. And to say, well, we're going to say in the notional world this was an avoidance transaction. Now, there might be a case where from the beginning the parties were only interested in avoidance. And that's not the case before this court. But if you had facts where the parties had from the beginning entered into arrangements with the main purpose of tax, and then the only rational conclusion from those facts would be that the notional transaction itself was imbued with that purpose. We say on our facts, it makes no rational sense, given that the direct transfer was in fact envisaged, it couldn't have saved tax, they never thought that it would, and it had commercial motives, to then ignore that bit of the background and factual reality.
But that, just to repeat, one of the things I'm concerned about, that's a sort of historical fact, if you like, that when they first thought about transferring to an SPV, they didn't think they were going to save tax. But by the time they did the actual transactions, they did, it's now common ground, have a tax avoidance motive, factually. And I'm questioning whether it's the same point that my lady's making, really, whether you can effectively put that out of your mind and say we're now in a notional world where we do not have regard to what was actually in the minds of the participants at the time the transactions were implemented.
Well, we certainly accept that the scheme transactions themselves were, we didn't accept below, but we accept now that there was a main purpose of the avoidance of corporation tax, and that was also pursued. But those are the scheme transactions, and it is the question before the court whether you can read that across. Now, and the reasons, the various reasons we say that you can't, but one of the key ones is it doesn't make any rational sense to say, well, there's a direct transfer, no one ever thought it could avoid tax, it wouldn't actually, no one ever thought the direct transfer could avoid tax, they contemplated something different, and those transactions, because it led to step up for corporation tax purposes and various transfer pricing rules led to a corporation tax advantage. Therefore, the alternate comparator, which was never thought to give rise to a tax advantage at all, that somehow would have that purpose in the notional world.
As I understand it, you're accepting that in a hypothetical case where the intention all along was, however the transaction was structured, to achieve some tax avoidance, then even stripping out the complexity might leave you with a problem under these provisions, because the intention, even in the hypothetical world, this different transaction would still have been tax avoidance. It might not be the same tax avoidance, but it might be something different.
Exactly.
In which case, sorry, just to carry that thought a bit further, and I'm sorry to put it this way, would it be the onus be on HMRC to establish as a fact that or in the absence of a finding of fact that was the case, the taxpayer is not to be hoisted with a particular petard of the tax avoidance intention?
Well, the burden of proof starting from the FTT would be on the taxpayer to show that the notion
of get into problems about burden of proof. So you've got findings of fact, as it were, in your favour. If you didn't, you might be in some difficulties.
Exactly. And we say that distinction accords with the purpose of the legislation, which is to counteract avoidance. Effectively, in a case like this, to say, well, what would the SDLT what SDLT would have been payable if the parties had not carried out this attempted avoidance. And in a paradigm case, there may have been SDLT due on that direct transfer. That's why the parties tried to get around it. In this case, there wouldn't have been. So that's the purposive reason why Section 75A doesn't apply. So, if the other way of looking at it, the way that the revenue would like you to look at this provision, it does turn it into a punitive provision, because effectively SDLT would be due on the group at 200 million when that would never have been the result even in the direct transfer. And it is relevant that Section 75A has been considered all the way up to the Supreme Court in Project Blue. They have said that it's an anti-avoidance provision. The revenue say it's an anti-avoidance provision. It's not one of those provisions in the tax code that is designed to be punitive, but the result of what the revenue is saying is punitive and would necessarily be punitive in other cases as well. And it also causes what we call a double bite by Schedule 7, Para 4A, the group relief anti-avoidance provision, which is page 131 of the authorities bundle. Because as is common ground now, the appellant in fact got no group relief was not entitled to group relief on the transaction that's before this court. That's why the best result the appellant can achieve is tax due on 30 million. If group relief applied, it would be nil because it would be exempt. So Para 2, subpara 4A of Schedule 7 has already applied to the appellant. It has already had a significant effect. And the revenue's interpretation is to cause it to bite again. And if we can go to page 289 of the authorities bundle.
Project view.
Project view, exactly. And if I could ask the court to read, from paragraph 42, about 5 lines down, there's a sentence starting the, all the way on the right-hand side. The heading is relevant. If I could ask the court to read from that to the end of paragraph 42. What the Supreme Court are saying there, it is sufficient, this is the top of paragraph 290, sufficient for the operation of the section that tax avoidance, in the sense of a reduced liability or no liability to SDLT, resulted from the series of transactions. And that's particularly important because section 75A doesn't have a motive test. So it's an anti-avoidance provision without a motive test. So it has to bite by reference to there being avoidance in fact, irrespective of whether or not there was a motive. That was part of what Project Blue was about. And it is therefore clear that there must be, so the Supreme Court say, reduced or no liability to SDLT resulting from the series of transactions which the parties put in place. So that must involve asking, well, what would have happened if the parties had not put these avoidance transactions in place, which is a fact-sensitive inquiry in a case that was all about avoidance and that was all the parties were ever doing. Well, that you might reach a different result. But that doesn't apply to our case. Because in our case, if the actual transactions had been entered into, the direct notional transaction, the comparator, the only rational inference is that it would have qualified for group relief. The parties directly envisaged it. It was the original plan. It is the natural comparator, and it's also the comparator under the legislation. And essentially what the revenues interpretation asks you to do is somehow stitch that up with remnant parts of the scheme transactions to make some patchwork quilt that was never considered or envisaged, with a share, with some of the scheme transactions disregarded, a share scheme a share sale somehow remaining and floating over it all, a purpose attributed that could never rationally have been the purpose of a direct transfer. It's a notional transaction that doesn't make any sense, and it's not the simple statutory question that the statute is asking. If this notional transaction were an actual transaction, i.e. the parties had carried it out, what reliefs would apply? So that is essentially our positive case on group relief as it applies to the notional transaction. I'm going to go through some of what my learned friends say in their skeleton. So, starting with paragraph 40, page 64 of the core bundle. So paragraph 40 is where the revenue skeleton begins on this point. Paragraph 40 itself simply is a supposed summary of our case, and it simply says this analysis is not correct at the end. So there's no real argument in that paragraph. In paragraph 41, there's a reference to 75C2 and the fact that that provides that the notional transaction gets the same reliefs as if it were an actual transaction, subject to the terms and restrictions of the relief. Now, there is no logical jump from, because the notional transaction is subject to the terms and restrictions of group relief, you must therefore judge that question by reference to the scheme transaction. That's the logical error in paragraph 41 and as the revenue go on to 42, because there's no logical link between those two things. And one of the reasons we know that is because section 75C3 which follows 75C2, does mandate that read across of purpose in a particular case. And in paragraph 42, the first two sentences are really assertion. The third sentence, starting as the FTT decided, one of the main purposes of the arrangements was the avoidance of liability to corporation tax. But of course, that again doesn't tell you whether or not you should read across that purpose to the notional transaction. And the FTT also found, as I've taken the court to, that the parties had contemplated a transaction identical to the notional transaction. They never envisaged that as being for avoidance purposes. And then finally, it's said by the revenue in that paragraph, there's nothing in section 75A to C which switches off para 24A. But as I've already explained, para 24A has already bitten the appellant. And we're not saying that you switch it off. We're saying that you apply it to the notional transaction. For essentially the same reasons, the revenue are wrong in paragraph 43 to describe our case as being that you cleanse the notional transaction. Because the notional transaction is a notional comparator, it doesn't start with an avoidance purpose that then somehow we need to show is disregarded. The notional transaction doesn't have that purpose in the first place. Now, paragraph 44, again, it's said that our case is that the notional transaction has to exist entirely in the abstract. Again, that isn't our case. We accept that the position might be different in the hypothetical example given by my Lord Warby, where the parties had always intended avoidance, and there was the only rational conclusion is that the notional transaction too would be for avoidance. And then the subparagraphs of 44, the revenue say, well, how else can you work out what the motives of the notional transaction are except by reference to the scheme transaction? And we say that the question of whether or not a notional transaction would have been entered into or was part of arrangements for the avoidance of tax is a question that the FTT can consider on its own terms. It doesn't need to bring in another fiction, which is that you attribute the scheme transaction motive to the notional transaction.
Well, there's a fiction going on to some extent.
Yes, there is, and it's about. We say our fiction is coherent because I'm sure the revenue say their fiction's coherent too. But on our fiction, you say, well, what you think about if the parties had actually done this notional transaction, and it couldn't have avoided SDLT. It was a direct transfer. It was never thought that it would. So that's a coherent notional transaction against which you can compare scheme transactions and say, well, have they actually saved any tax? We say that the revenues comparator is not rational. It's this sort of odd patchwork of the motives of something that could never have been the motives of something else. Now, paragraph 44, 4, it is said that group relief would only be available if the real-world relationship between the vendor and purchaser is taken into account. But again, section 75A gives you the rules on how to identify the vendor and how to identify the purchaser.
Sorry, are you on 45?
44 little 4.
I'm on 44 sub 4.
Could you repeat your point? I apologise.
Yes, so the revenue say that you need to take into account the real-world relationship of the vendor and the purchaser. But that's straightforward. That doesn't require any additional fiction because the identities of the vendor and the purchaser, you can deduce those from the statute. And there may be cases where it's difficult to apply the legislation to work out who the vendor and the purchaser was. Project Blue was such a case. But still, you have to deduce who the vendor and the purchaser are. That's what the legislation tells you to do. And then you simply say, well, are these parties in the same group as at the effective date? You don't need to posit some additional fiction. And we say the same essentially for sections 53 and 54. You apply those sections on their terms to the notional transaction, and they too do not require some additional fiction. So those are my submissions on the first of those two section 75A issues, unless I can assist on that point anymore.
You.
So turning now to section 54, the case 3 exception, whether that applies to the notional transaction. This issue arises if you're against me on the group relief. So if we could turn up page 47 of the authorities bundle. we have therefore at subparagraph 4 the case 3 exception, and the two conditions in sub A and sub B. Now, subparagraph B we can deal with quite briefly, since the dispute between the parties is limited to whether or not subparagraph A is met. And the reason for that is because of the disregard in section 75A. So because section 75A tells you to disregard land transactions that are part of the scheme, and it's common ground in respect to the notional transaction that there is no prior transaction in respect of which group relief has been claimed. But subparagraph A is in issue, provides that it applies where the vendor is a company, the notional transaction, the vendor is SGSL, it's common ground, SGSL is a company. And then the question is whether the transaction is or is part of a distribution of the assets of that company, whether or not in connection with winding up. And for this, we need to apply Schedule 16, paragraph 3, which we looked at briefly earlier, but if we can turn back to it, it's 141 of the authorities bundle. And subparagraph 4, the relevant subparagraph for our purposes, where a lease is granted by a person as bare trustee, so it's uncontentious, that applies, he is to be treated for the purposes of this part, so that includes section 53 and section 54, and therefore the case 3 exception, as it applies in relation to the grant of a lease, as vendor of the whole of the interest disposed of. And it's clear that by the reference to the whole of the interest disposed of is a reference to a legal and beneficial interest. An undivided interest. The revenue's position is, in short, that the trustee, in this case SGSL, cannot make a distribution within the case 3 exception because it's merely a trustee, and so a disposal would not be of their assets and so would not be a distribution. That's how we understand the revenue's case. But that has a number of issues. First, it runs against, we say, the very wording of subparagraph 4, particularly the reference to being the vendor of the whole of the interest disposed of. In the case of a bare trustee, that can only mean the legal and beneficial interest. And the wording of case 3 is it a distribution of the assets of that company? So if you're applying Schedule 16, sub 3, para 3, 4, it must be the interests of the trustee company. It must be the assets of the trustee company. It couldn't be anyone else's assets, and they're treated as the vendor of the whole of the interest. And secondly, if the revenue were right, then case 3 in section 54 could never, we don't see where it could ever apply in relation to the grant of a lease. Because it couldn't be a distribution of the beneficiary company.
Sorry, you mean where it's granted by a trustee?
Yes. Because it couldn't be a distribution of a beneficiary company. The beneficiary is essentially ignored by para 3. And the revenues say that it couldn't be a distribution of the trustee.
Do you say that the deeming in paragraph 3(4), I think you must say this, extends to treat the trustee as vendor for all purposes, including as receiving any consideration. So that if this were an arm's length sale, there wouldn't be distribution, for example.
Yes.
I think you must say that.
Yes, subject to there being any specific provision in the rest of the Act dealing with any of those points. Because 3 sub 4 says for the purposes of this part, so it must follow through. It must apply in relation to each section of Part 4 of FA 2003, i.e. the whole SDLT code. So if the revenue were right, the case 3 exception in section 54 could never apply in the case of a bare trust and the grant of a lease. We say that there's nothing anywhere that suggests that that conclusion was intended. It will be a significant conclusion affecting the whole code. And if we can turn up the revenue skeleton, core bundle 66, paragraph 47. The revenue deal with this point in paragraph 47 of their skeleton. And the sentence that really contains the reasoning in that paragraph is the third one, where it says, nothing in the relevant SDLT legislation alters the real-world application of company law and accountancy requirements relating to the making of distributions. That's their principal point. And we say that should be rejected. First, the revenue haven't actually particularised what company law or accountancy requirements they say apply here and are not met. They haven't pleaded that or relied on any provisions of the Companies Act or any other act. And secondly, there is no definition of distribution in the Finance Act 2003. But in particular, there is nothing that brings in the definition of distribution in section 829 of the Companies Act 2006, which in any event is stated to apply in this part. Nor is there anything that, for example, brings in the Corporation Tax Act 2010 definition of distribution in section 1000 of that Act, which applies to the Corporation Tax Act and not to SDLT. We say this was a distribution in the ordinary meaning of that word. It was not for value. It was not a sale.
Well, that's part of why I asked the question. It was for 30 million, wasn't it?
Yes, which is a undervalue.
But you say that, well, I'm not sure that HMRC dispute that that's capable of being a distribution, but you say that's a distribution in normal parlance.
Yes, and if there is a reason why it's not a distribution that's not set out in that third sentence in their skeleton of paragraph 47, then I don't know what it is. The revenue did take the point below at one point that the distribution at the third stage of the transaction, so the distribution to the appellant, was not a distribution, and then they dropped that point. But what the sole ground that the revenue seem to be relying on is paragraph 3 sub 4, and the fact that because the vendor was a bare trustee, then somehow it cannot be a distribution. We say that doesn't make sense because it would exclude the operation of case 3 entirely from any bare trust and grant of a lease.
Thank you.
I'm conscious of the time. I'm probably going to be more than 25 minutes on the 75A point, and I might be able to be quicker if I...
How long will you be?
About 45 minutes, something like that.
On that basis, I think we'll adjourn now and begin again tomorrow at 10:30. Thank you very much, everyone, so far. Please, I know there is a transcript being produced. Please may we have a copy of that as soon as possible, both in hard copy and preferably electronically. That would be very, very helpful. Thank you.
Supervisor Abel.